Larry here with 7 Sage Law School Prep. This is one of two analyses of actual student answers to the winning entries in our drunk texting for $100 Starbucks gift cards contest. Quick reminder, the fact pattern's based on this posted text exchange between a drunk person and someone pretending to be Doctor Who. This is further narrowed by issue. You were asked to only analyze whether the drunk person could sue Doctor Who fan for intentional infliction of emotional distress. So this is the answer of Carrie Richards. What you're about to see is most useful if you have already taken the practice exam by yourself, reviewed the self-scoring sheet, reviewed the video I already did as a matter of my general comments. Also, you'll probably get more out of this if you've reviewed both of the student answers by Umara and Carrie and the previous video on Umara's answer. As with last time, I'll be reviewing three main things in this exam: word economy, word choice, content and analysis, and structure. Let's start at the beginning. I think this is right, but as with Umar's analysis, you could have dispensed with that introductory paragraph. You jump right into reciting the rule. Let me go with the small word choice things here. I love the immediate use of D, a single letter, P. I love the immediate use of initials. I do think that it's better not to use these, what I'll call relative references. So texter or drunk texter or something, but it's difficult because there's D in both. So D for defendant and doctor, that's fine. Maybe T for texter here. Let me go back a sec. Again, I think the issue can be stated something like this, and you can have shorter headlines for each of the separate analyses of the elements. I would just say intent here. You do take some time here to unpack this. I think this is quite reasonable. I'm not sure that this is the standard. It is clearly something that what I've set up leaves kind of ambiguous. Defendant acted intentionally or recklessly, but I don't really say anything about whether or not you had to have intended the distress. Again, I think as a practical matter, in this fact pattern, it's reasonably clear that the Doctor Who fan did intend to distress the person. The Doctor Who fan keeps sending text after text after text, and the story gets more and more elaborate. I mean, if you review these are kind of fantastical. Sorry, I'm just going through very quickly, but it's very calculated to bother the person receiving these texts. But let me step back for a second. I don't know that I agree with every line in this paragraph, but what I love about this is that it's a very nice he said, she said, argument, counter argument. It's very nitpicky. I think the next level would be to have a little more structure here. Sometimes watching a ping pong match can be kind of difficult, but professor reading this, I feel like will know that this is pretty good. As to some of the line items, I think I wouldn't have said this. This is beyond the reasonable inference. This is a stretch. We have no reason to believe that someone took the Doctor Who fan's phone. The introduction to the whole thing presents the texts as her friends, the Doctor Who fans. So I wouldn't say something like this because it's basically contrary to the facts as given. What I love about it is when you're the texter, Carrie, you're fully engaging the texter, you're being as aggressive as you can, and then you flip to the other side, and I think this is right. Then Doctor Who was saying that she wasn't serious, that this was all lighthearted, and I tend to agree this could be thought of this way, a close question, but I think that Doctor Who fan would fulfill that. Here we go on to the next element, and I would tinker with this a bit, something like that, just a headline. I'm not sure this was necessary, but it's nicely nitpicky, noticing that it's extreme and outrageous as opposed to intentionally or recklessly. I like the attempt to flesh out the content of this element, given that you're not given very much. And I do think the way this is presented is pretty good. This is probably the best argument that the texter has. There are a bunch of ridiculous things that the Doctor Who fan says, but to tell the texter that she was in grave danger starts to get close to shouting fire in a crowded theater. I mean, if you focus on just that one word, I think in the greater context of things, it's still kind of ridiculous. What I like about this is not that it's necessarily right, it's the best argument. It's one of the best arguments that you would come up with. Then, this is great, you flip immediately over, here's D. D would claim that an average person would not be distressed by a text message from a stranger. that is one of the best arguments that the Doctor Who fan would come up with. You then jump right into a counter argument, and I'm not sure that any of this is actually embedded in the IIED claim. I don't know that that there's any kind of reasonable person or reasonable drunken, intoxicated person standard that's applied to this stuff. But you jump in, yeah, it's different. You can't text someone who's drunk and gullible like this. This is a great back and forth. I think ultimately, I'm not sure that I agree with the conclusion that this is extreme and outrageous. That's partly for reasons that you could not have known before, given what actual extreme and outrageous conduct is, that it's stuff like your mom died and you just kind of pursue a lie like that to someone and shocking them or killing a loved one right in front of them are the classic scenarios. As I mentioned before, I think the problem with this is it's so inherently unbelievable. I have some other small quibbles with the analysis. This is an old standing TV show, but it's vaguely cultish. It didn't have a huge audience over the years. But I think this is the key line. Even if P hadn't heard of it, she should have realized that all this was outrageous. Time traveler from 1969, texting someone on their iPhone. It is all inherently ridiculous. This is what I'm a little confused about is the extreme and outrageous nature of the conduct. I don't think depends on P's intoxication. I think this stuff is either extreme and outrageous or it isn't. I don't know if the standard would change based on someone's mental capacity. I suppose directing somebody who's mentally disabled or a very young child to do something insane because they would believe it might fall into this, but I think this is an adult, and I'm not sure that one is necessarily more gullible when drunk. Moving on to the next piece here. Again, I think I would shorten this to causation, and I think this probably is a shorter analysis. It's clear that Doctor Who's actions are but-for factor here. And here you're kind of borrowing clearly from negligence. I do think that the split in the causation element under negligence is there kind of naturally, where you have actual but-for causation. Something happened because of something you did, just as a matter of fact. And then there's this other element of legal causation, that there are all these other potential intervening factors. There's a little bit of analysis, a little bit more of analysis to be done here about legal causation as to whether or not any distress that P experiences partly due to her own gullibility in believing inherently implausible stories. I suppose in the end, given the oversimplified elements for IIED that I gave you, that what you're left with is just but-for causation. Let's go to the last element here. I think this one can be reduced to just that severe emotional distress as a headline. I think there were a little more back and forth that could have taken place here, but I think this is basically the right analysis. This is a reasonable inference, right? You're only given the text of the texts, and you don't really know anything about P's actual mental state. But this is a great inference, the fact that P continued to text, even though she said she was suffering a panic attack, she was being hyperbolic. That is, if you actually are physically incapacitated by panic attack, heart palpitations, dizziness, it's unlikely that you can still semi-coherently text. Maybe some people can, maybe some can't. The fact is, it's not undebatable. This is a conclusion you could reach based on the facts, and it's the one that Doctor Who fan would argue. This is how I think I would come out on this element. I think this should be a separate paragraph. This is your overall conclusion, and I think you would want to mark that. Again, the overall conclusion's not important, but I think I agree here that there's at least one element missing and that there's no IIED here. To be clear, I think just based on the analysis as is, this was one of the best contest entries. Something else that I liked is this. There was an additional analysis that followed, and I thought this was super creative because this case wouldn't hold up where the drunk texter is suing the Doctor Who fan for IIED. Carrie here's looking for a different claim, and it's not something that you were instructed to do in the question, but it was greatly creative. And one thing that could be explored is IIED for the posting of the exchange on the internet. Great thought. Now, what I love about this is specifically that it's a colorable claim. It's not even likely to prevail, but it's not frivolous. It's at least worth doing the analysis to see if you can make a claim. In real life, the reason that you want to do this is sometimes You can't read a judge and you don't know what's going to stick. I've actually seen in litigation practice sometimes a third or fourth claim that you stick into a complaint that you think is a little bit far-fetched is the one that the judge actually buys in the end. This is very much why the law, and even law professors who haven't practiced law very much recognize this. This is why it's quite important to be creative about claims, to reach for things. It's not about dead-on answers. If you are trying to work up something for a client, you give them an honest assessment. You say, this claim is a good one, this claim's more likely to prevail, this one's less likely to prevail, but you go after iffy but still non-frivolous claims because you don't know. They might hold up, and you very often need alternate arguments. That said, I think that this is merely colorable claim because IIED doesn't fit those facts super well. There's definitely something here if you intentionally published something to shock someone. But again, this is perfect because I only told you to analyze IIED. In real life, it's likely that this fits some other tort, some sort of invasion of privacy tort for a person who's not a public figure, maybe some sort of defamation tort. I would unpack this a little bit more. I feel like this is a good analysis, but you want to separate the other angles for the client to recover. A claim against D and D's friend. You know, maybe they're two different people who are liable there. If you were to do this more fully, and you did a pretty thorough analysis, Carrie, you'd really want to do two separate IIED claims, one against D and one against D's friend. Certainly, like the publication here is intentional. There's some element of it where you can't tell if the person's doing it to humiliate the drunken person. There's an element of look at how stupid this person is who believed this. So I think in the end you could get to some sort of intentionality or even recklessness. And I think actually this might be backward. You say that recklessness would probably not hold up. It might be the opposite. I think it's the Dr. Who fan and her friend are kind of indifferent as to whether or not this hurts that other person's feelings. You know, it is sort of a haha, look how stupid, but they may not mean to cause extreme distress. Something like this where you know that like thousands, if not millions of people are going to read this, maybe you're reckless. Jumping to extreme and outrageous conduct to post the text exchange on a well-trafficked site. I think this is an interesting analysis. You're right. I think it might not be a stretch to think a judge would say that this is kind of extreme and outrageous. I think something that's super interesting here is the anonymity of the person whose texts were being posted. You don't know who it is, so people are laughing, and I think that would be a good he said, she said bit of analysis. Well, as the texter, you'd argue, millions of people have seen my texts, I'm embarrassed. Dr. Who fan would say, nobody knows that it's you, you're not being bothered by them directly, it's just your texts that were stupid. So it's perhaps even more believable that, jumping ahead here, that emotional distress could be even stronger from the posting of this set of texts, whether or not the texter remained anonymous. I think some of the analysis that goes here might well belong in number 3 or number 2. This just has to do with, well, was the actual shock, severe? Again, there is some overlap in the elements, but here I think if we just focus on the emotional distress, this seems to point to whether or not the texter should have been embarrassed, and I think that might fall within here as to causation. Certainly D's was a but-for factor, and part of what I think an ultimate analysis by a judge would do is look at legal causation. Certainly posting the text might have been embarrassing, but whether or not something like this, which is, reasonably common given the number of tumblers that in people who post stupid text exchanges, commonness of that, whether or not we should find that there's causation and say that D caused any distress that P had as another. I tend to think ultimately that this claim might fall apart. It's colorable more because of the extreme and outrageousness of it. This seems to happen a decent amount. You don't have the things like the classic IIED things happen that often. People don't prank call other people often to say, hey, your mom died. They don't kill loved ones in front of other people very often. And so the commonness of posting texts or embarrassing exchanges or this sort of public humiliation seems to weigh against saying that this is extreme and outrageous. It happens a lot. Maybe it's not great. And certainly I agree that there's at least an argument to be made that a judge might say that, this is extreme and outrageous. But as a policy matter, and sometimes that does weigh into something like this, especially if you don't have case law on point. As a policy matter, maybe we don't want to say that this is extreme and outrageous. Given how many claims you might bring up, or given somebody Facebooks about you, you could suddenly sue everyone. And half of Facebook is complaining about other people, aside from putting up pictures of food and other useless things. Anyway, I thought that this was a good analysis overall. Again, this is still an early answer, but it showed really good flashes, nitpickiness, back and forth analysis, and legal creativity. So, Carrie, good start. Keep up the good work.